And I'd like to welcome you all to the 14th edition of the Willem C. Vis International Commercial Arbitration Moot. This morning, our claimant is Right Limited, represented by the team from NALSAR University School of Law, and the respondent, Santos DKE, is represented by West Bengal National University of Judicial Science. Our tribunal this morning is made up of Dr. Horpang, who is the rector of the National University of Management in Phnom Penh, Cambodia. Dr. Eleonora Chelo, who is the Secretary General of the Arbitration Center of the Brazil-Canada Chamber of Commerce. And in the chair is Ambassador David Huebner, who is an independent arbitrator practicing in California, United States. And with that, I pass the microphone to the chair.
Thank you. Council, welcome. Is there a proposal, a joint proposal from Council for order and time in the proceeding this morning?
Yes, Mr. President. The respondent procedure will go first, followed by claimant procedure, followed by the rebuttals on procedure. Post that, the claimant will start on the merits of this dispute. Respondent will respond to the same, followed by the rebuttals on the merits. Each speaker will be speaking for 14 minutes, reserving 1 minute for rebuttals.
Okay, we will let you manage your own time within the overall parameter. Is that agreement acceptable to you?
We are in agreement, Mr.
Madam Arbitrator? Perfect. Very good. As you've heard, my name is David Huebner, your President Arbitrator. To my right,
Eleonora Coelho from Brazil, comes CCBC General Secretary.
very good. Council, are you ready to start?
Absolutely.
Please do.
A very good morning, members of the tribunal. My co-counsel, Mahima Chalera, and I, Sania Mirani, represent the respondent, Santos DKG, in the present proceedings. The parties in the present dispute entered into a contract for the joint development of fan blades. Through the present proceedings, claimant seeks an additional amount of approximately $2.5 million through an application of the current exchange rate, in spite of a fixed exchange rate clause in the contract added through an addendum. Members of the tribunal, this disregard for parties' agreement is also reflected in the manner the claimant has initiated the present arbitration proceedings, as I will establish that the present arbitration proceedings have been initiated beyond the contractually agreed time limit of 60 days.
Ms. Mirani,
Yes.
how do you reconcile your understanding with the Article 2.6I from the CAM-CCBC rules, in which the president of CAM-CCBC has the power to extend the time limit for parties to correct defects on the request for arbitration?
Madam Arbitrator, the act of Mr. President to give an extension of 10 days to correct the defect was merely an administrative act, and it was not a judicial determination of the legal rights of the parties. It is upon this tribunal today to determine whether proper initiation was undertaken on the 31st of May. Thank you. If the tribunal does not find with us on the issue of admissibility, we request this tribunal to order the claimant to provide a security for the course of present proceedings, proceeding with the first submission concerning inadmissibility. If I may direct your attention to page 10 of the record. At the bottom of the page is reproduced the dispute resolution clause. The last sentence uses the word 60 days after the failure of negotiations. Members of the tribunal, the consequence of the expiry of the 60-day time limit is that the arbitration proceedings will be barred if initiated post this 60-day period. I will establish first as to when the 60-day period was triggered and when it expired. I will then, yes.
Ms. Marani, before
Yes.
we get to that, it strikes me there is a predicate issue of jurisdiction. And what confuses me about your argument is that in your initial responsive pleading, you appear to have conceded that this tribunal has jurisdiction. I interpret your current argument as essentially we do not now have jurisdiction. How do you reconcile your current argument with your initial pleading?
Mr. President, as it has been stated in Procedural Order 1, this dispute does not concern the jurisdiction of this tribunal. Jurisdiction is about the mandate of this tribunal to go beyond the arbitration agreement. However, admissibility concerns the locus standi of the parties, and it is our submission today that the claimant does not have the requisite locus standi to bring this claim, as it was beyond the contractually agreed 60-day period.
What is your advice to claimant on what they do if we hold that there is no admissibility in front of this tribunal? Do you interpret the dispute resolution clause as barring all recourse, or do you read it as their next step is to file in court?
Yes, just to complement your question, what's the nature of the time limit?
Mr. Arbitrator, to answer your question first, the expiry of the 60-day time limit does not restrict the claimant's recourse to the courts. The interpretation of whether Section 21 bars access to the courts will be dependent upon the court's interpretation of this clause. If the courts do not deem fit that they do not have the jurisdiction on the basis of interpretation of Section 21, they may give up their jurisdiction. However, the claimant most certainly have the recourse to courts, and upon an interpretation of this clause, will the court decide whether they can approach the courts or they cannot. Madam Arbitrator, to answer your question, 60-day time limit is an obligatory time limit in nature. After the 60-day period is over, no party can initiate the arbitration proceedings. The right to initiate arbitration proceedings was agreed by each party, and it was agreed freely and not unilaterally by any of the parties. And therefore, if today this tribunal were to hold that initiation of arbitration proceedings were beyond the 60-day period, it would violate the valuable rights that accrue to a client to have the arbitration proceedings initiated within this 60-day period. Members of the tribunal, if I may elaborate on when this 60-day period was triggered. As it is evident from Section 21 itself, the 60-day period is triggered the date on which negotiations failed between the parties. If I may direct your attention to page 29 of the record. This email was sent by the COO of the claimant, Ms. Bainhorn. In the email, she acknowledged that there existed certain irreconcilable differences between the parties which could no more be resolved by a process of negotiation. In the very second paragraph of the email, she explicitly mentions that the claimant has instructed a lawyer to initiate the present arbitration proceedings. Members of the tribunal, the tone and tenor of the email when read together indicates that the negotiations most certainly failed on the 1st of April, thereby triggering the 60-day time limit on the next business day, which is 2nd of April. Accordingly, 31st of May 2016 was the last date to initiate the present arbitration proceedings.
But Ms. Mirani,
Yes.
didn't respondents' silence to that email, couldn't that silence be interpreted according to Article 18 of CISG that negotiations did not fail?
Members of the tribunal, the indication of when there is a failure of negotiations is when, from the facts, it is most certain that there exists a perpetual deadlock between the parties. There was no reason for our client to respond to this email, as the meeting that was held on the very previous day to this email most certainly indicated that there existed such fundamental differences between the parties that they could no more be resolved by negotiations. Furthermore, as it is evidenced in the case of Vekoma, silence on behalf of a party further indicates that there has been a failure of negotiations, and therefore silence of the respondent can furthermore be construed to be an ending the negotiation process, and therefore this not replying took the present dispute resolution process one step up, and we were now most certainly at the stage to arbitrate the present arbitration proceeding. If I may now move on. If we may turn to page 21 of the record, the power of attorney that has been reproduced on page 21 was submitted on the 7th of June, which is beyond the 60-day time limit. And as a result of this, the non-submission of the correct power of attorney by the 31st of May makes the present arbitration proceedings not valid. If I may therefore move on to my next submission concerning security for costs.
Counsel, what is the, oh, sorry, please. Dr. No, please.
Respondent, I have two questions
Yes.
regarding to time limit. What is the reasonability behind such a limitation? Is it the term failure of negotiation to verge?
Mr. Arbitrator, if you may please rephrase your question.
Yeah, you don't catch my question. What is the rationale behind such a limitation? Please explain. Is it the term failure of negotiation to verge?
Mr. Arbitrator, the reason behind inserting such a limitation period is so as to improve cost efficiency and time efficiency. And the parties did not intend to resolve the dispute beyond the 60-day period in order to achieve both these purposes. Members of the tribunal, if I may also. Yes.
Counsel, as to the second part of the question,
Yes.
what is the standard you suggest we apply in determining whether or not that particular limitation was too vague for us to enforce?
Members of the tribunal, if I may refer to the case, ICC case number 8445, where a similar dispute resolution clause was adopted. The clause only mentioned an amicable settlement of dispute, and the tribunal interpreted this clause to not be vague, as the amicable dispute resolution would entail the parties to only resolve the dispute till the time it was commercially viable for both the parties to resolve it. In the present proceedings, the parties have tried to resolve this dispute for the past 14 months. And it was only after these 14 months that the email was sent by the COO of the claimant, and therefore it was no more commercially viable to resolve this dispute by negotiations. If I may therefore proceed to the second submission concerning security for costs. Article 8 of the CAM CCBC rules allows this tribunal to grant an interim measure. Since security for costs is a form of an interim measure, this tribunal indeed has the power to order security for costs. Members of the tribunal, Article 8 does not prescribe a criteria for granting such an interim measure, and I therefore rely on the relevant lex arbitrae, which is the Danubian arbitration law, which follows the UNCITRAL model law. Article 17 prescribes 3 conditions for granting any interim measure, the first of which is to establish that if security for costs are not granted, a harm may be caused that cannot be adequately repaired by an award of damages. Members of the tribunal, today, if security for costs were not granted, our client will not be able to recover the costs of the present proceedings. And the reason why such a harm may occur is on account of the precarious financial situation of the claimant. If I may direct your attention to page 59 of the record. Members of the tribunal, let us look at the 2 most certain things that are evident from the balance sheet of the year 2015. The first most certain thing is the amount of cash and cash equivalents that they currently possess. This is not even equal to $200,000, which is the legal fee of our attorney.
Ms. Mirani, but isn't this liquidity strain only temporary, and as it parts of the business of the claimant?
Madam Arbitrator, it is not only the liquidity concern that makes our client fear. It is also the amount of non-current assets that they have that makes us fear. If I may elaborate, currently, if we look at the amount of plant, property, and equipment that they possess, it is approximately equal to 37 million. However, juxtaposed with this tangible asset is the amount of liabilities that they possess, which is equal to $40 million. Members of the tribunal, over and above this $40 million, another liability has accrued to the claimant. The claimant has not honored an award worth $2.5 million in an arbitration proceeding rendered against the claimant. $2.5 million added to the current liabilities mean that the claimant has a liabilities to the amount of $42.5 million, juxtaposed with the only tangible non-current asset of plant, property, and equipment worth $37 million. Members of the tribunal, it is our fear that the claimant currently does not have the realizable assets to satisfy any costs award. The amount of non-current assets may be charged with the amount of liabilities that they possess. The amount of intangible assets and the amount of receivables are only speculative in nature, and they only show the book value of these assets. It does not show us that these assets will realize the market value as it is reproduced in the balance sheet. The amount of cash is also not sufficient, and therefore, on account of members of the tribunal, I see that I have exceeded my time. If I could get 30 seconds to conclude my submission. It is on account of the precarious financial situation of the claimant that we seek an order for security for cause. Members of the tribunal, to conclude, we request this tribunal to declare the claimant's claims as inadmissible and also to order the claimant to provide security for the cost of the present proceedings. Thank you.
Thank you. Any further questions at this point? Please do.
I do have a last question on this subject, Ms. Mirani. If the tribunal granted the security for causes, wouldn't it threaten claimant's right to a fair hearing?
Thank you for your question, Madam Arbitrator. We would request this tribunal to order security for costs in the form of a bank guarantee. This form would ensure that the claimant's liquidity position is not further deteriorated, and it was also provide an assurance to our client that at the end of these proceedings, if the claimant were not to honor the cost award, the banks would come to our rescue. Thank you.
Thank you.
Mr. Vassant, are you ready?
Yes, Mr. Arbitrator.
Please proceed.
Good morning, members of the tribunal. Over the course of the next 14 minutes, I will mirror the order of submissions of Ms. Mirani and argue firstly that the claims of our client are admissible as there was a timely commencement of arbitration, and secondly, that our client must not be required to provide security for the costs of this arbitration. The respondent states that the entire agreement was for the joint development of fan blades, and this was in light of the amicable relations between the parties that existed. However, the procedural claims that the respondent brings today threatens the only certainty that our client had in this agreement, which is that we would either amicably resolve these disputes at the behest of each other or at the behest of an arbitral tribunal. Ms. Mirani stated that this agreement would allow our client a recourse to the courts of law in case this tribunal did not uphold it. However, it must be noted that the courts of law, especially considering that the CAM-CCBC rules are the institutional rules adopted here, would be extremely reluctant to allow this particular dispute to be litigated, and in fact, there needs to be an exceptional withdrawal of jurisdiction by this tribunal, as held in the CAM-CCBC commentary, for a court of law to litigate a dispute that has been agreed in arbitration. Therefore, the claims that the respondent makes today seek to stifle our client's access to arbitration merely for the want of one document, and about $50 of cash equivalents. If I may move to my first submission on admissibility. The respondent states that there was an irreconcilable difference between the parties that arose on the 1st of April. Now, essentially, there was a stalemate of negotiations on the previous day, on the 31st of March, and exactly 1 day later, our chief operating officer, which may be found on page 29, sends an email requesting the respondent to move beyond its position so that any meaningful negotiation can take place. And the respondent states that that particular email on that particular date should have meant there was a failure of negotiation with the very action that my client chose, which was to extend an olive branch in this negotiation process. Ms. Mirani stated that the tone and tenor of the email would indicate there was a failure. But if I could take you...
Counsel, but didn't in your email you make clear that negotiations were over by informing that you have instructed your lawyer to commence the legal dispute?
Madam Arbitrator, allow me to answer that in two parts. Firstly, you would note that the second paragraph of this email speaks about the initiation of the arbitration proceedings. However, the third and the fourth paragraph are qualifications to that, wherein our client clearly indicates that they are intent to continue negotiations and that they indeed want to settle. The second part of my argument stems from the standard of a perpetual deadlock which Ms. Mirani herself quoted. This was observed in ICC case 6276 and was defined as a persistent deadlock exists between the parties when the facts indicate that there is no other way but to arbitrate or litigate. In this very email, in the words of this very email on page 29, you would note that Ms. Beinhorn characterizes the predicament of the parties as a present inability. She notices that the intent to go to arbitration will only be a last-ditch effort and indicates that we want to continue negotiations and indeed that our client wants to settle. In any case, members of the tribunal, there was no way for our client to notice the silence of the respondent to this email as a failure on that very date. Sometimes, the respondent took as long as 26 days to reply to crucial communication, for example, with reference to the invoices in this dispute. And therefore, there was no way for us to know that this failure occurred on the 1st of April by this very email, since there was a silence. I sense you have a concern, Mr. Arbitrator.
Yeah.
However, for the purposes of this dispute, even if we were to assume that there was a failure that occurred on the 1st of April, I will submit that there was a valid commencement of arbitration on the 31st of May, which the respondent concedes is within the 60-day time period.
But, Counsel, doesn't Article 21 of the Nubian law provides that arbitration proceedings only commence on the date which the other party receives the request for the dispute?
Madam Arbitrator, now Article 21 of the Danubian arbitration law is prefixed by unless the parties have agreed otherwise. Here the parties have chosen the CAM CCBC rules explicitly, and under that it would be, in fact, the CAM CCBC website itself states initiation would mean the compliance with Article 4, which we state has been done on the 31st of May. If I may continue. Our client's burden...
No, because in fact, CAM CCBC rules establish the registration fees a precondition in order to commencement of arbitration. How do you reconcile these provisions of CAM CCBC rules with your statement?
Indeed, Madam Arbitrator. We must note that our client was to initiate arbitration under the CAM CCBC rules read in line with international arbitration practice as the agreement requires us. Now, the CAM CCBC rules are silent regarding what happens when there is a faulty application. They surely deal with what happens when there is an incomplete application. But we must note that the two errors that our client's application possessed on the 31st were mere technical, clerical errors, which were clear to the Secretariat of the CAM CCBC. And since the CAM rules are silent, if we look towards international arbitration practice, I could quote a bevy of rules ranging from the ICC, the HKIAC, the LCIA, the Singapore Institute, the Vienna Institute, all of which allow a time period within which these technical deficiencies can be corrected, and allow for the date of the request for arbitration to be the date of commencement, even when there is a subsequent modification. I rely on these standards because all of these rules have differential requirements for what constitutes a valid application, but they all allow for these technical deficiencies to be corrected because the principle is that a party's legitimate claim and access to arbitration must not be barred merely for want of formal documentation. And that precisely was the purpose of the 60-day clause here, to prevent frivolous claims that arose after a long period of time.
But counsel, talking about the intention of this clause, isn't it to create legal certainty?
Indeed, Madam Arbitrator, it is to create legal certainty. However, the legal certainty created was not vitiated by our client's application on the 31st. We must note that the President of the CAM CCBC and the Secretariat, who has a power to reject frivolous applications, do not do so. And in fact, if you will turn with me to page 40 of the record, the President and the Secretariat clearly use the words application submitted on the 31st and amended on the 7th, and not substituted or replaced. Therefore, we must note that since this is in line with the intent of the parties to arbitrate, and in line with international arbitration practice, which is a relevant threshold for both this agreement and the CAM CCBC rules because they have an agenda of internationalization, this tribunal must note that our client corrected these deficiencies within a stipulated time period that the Secretariat provided us with, and therefore stifling our client's access would not be justified. And therefore, if I could conclude, this tribunal must find that our client's claims are admissible. To turn to my second issue regarding security for costs, the respondent submits that the power to order security stems from a general provision under Article 8 which allows for any interim measure. However, security for costs is an exceptional interim measure because it lays a significant obstacle in one party's access to arbitration even when it is complied with. And it is for this reason that Professor Van Euler notes, rightfully, that there needs to be a specific indication in the entire system of law, somewhere in the entire system of law, which allows for this power. Both Article 8.1 of the CAM rules and Article 17 of the Danubian arbitration law do not have such a specific indication. In fact, we must note that Danubia, the seat of arbitration, does not amend Article 17.2c to include a power to order security, unlike other model law jurisdictions such as Hong Kong, Singapore, or even Canada. And in fact, therefore, it's no coincidence that there is no decision on security for costs in Danubia. However, even if there exists a general discretion, we must note that this tribunal must be dissuaded from ordering security for two reasons. Firstly, if I may refer you to page 43 of the record, the terms of reference agreement between the parties exists on this page. Here, under section 12.4, the parties have agreed that they will bear their costs, their respective costs, for attorneys' fees and witnesses' fees. And under Article 10.4.1 of the CAM CCBC rules, the commentary states that the tribunal will absolutely follow the parties' choice in the arbitration agreement or in the terms of reference. This is not so far as to say that the tribunal cannot change this allocation, but only that under the arbitral award can they change this reapportionment. Therefore, an interim measure to order security may be contrary to the agreement of the parties.
But, counsel, didn't claimant's situation deteriorated since the parties concluded in the arbitration agreement, and that would be a sufficient ground for the arbitral tribunal to grant the security for costs?
I understand your concern, Madam Arbitrator, and I will move on to address it. This deterioration needs to be an exceptional one which was not contemplated when the arbitration agreement was signed, or needs to be one which is not a normal incident of business. And if I may refer you to page 59, which contains the financial statements, you would note that this deterioration is neither. In fact, This is a normal incident of business because our client has received incomplete payment for one fan blade and is in the production cycle of another fan blade. And in an industry as research and development heavy as the fan blade development industry, there is bound to be a liquidity strain.
But Mr. Vazant, how can you explain, I come from Brazil, as you know, and I know that Carioca Business is a very reputable press vehicle. How can you explain the news published in the Carioca Business, and I quote, "The message refutes concerns about the financial situation of Right Limited"?
Madam Arbitrator, now the author of this particular news article may have concerns. However, these concerns need to be legitimately grounded in legal standards. And if we allow for Article 17A of the UNCITRAL model law, along with the nuances in security that security for costs throws up in practice, the Chartered Institute of Arbitrators notes a two-pronged test. They state firstly, a party must not be able to bear an adverse cost award, and secondly, that it must be fair to order security. If we look at the financial statements, the intangible assets of the claimant have increased manifold from when the agreement was signed. In fact, the cash and cash equivalents to is larger than able to bear the legal costs. And all of this is said to be augmented by the fact that the TRF 305 fan blade is soon to be released and will increase the cash flow of our client. Ms. Mirani was also concerned about the long-term assets of our client. We must note that the long-term risk-bearing capability of a company is measured by its debt-to-equity ratio in industry. And the debt-to-equity ratio of our client has increased from 20:1 in 2009 to 5:1 currently. Members of the tribunal, I see that I'm close to running out of time, and if I could request for 30 seconds to sum up my submission. And therefore, since there is the possession of assets and it is a normal incident of business, we must note that our client is functional, solvent, and even profitable. And therefore, we will be able to bear an adverse cost award. It would not be fair for this tribunal to order security, as the only risk that the respondent has is that it has to enforce its award in a court, which it anyway does under the New York Convention. But our client would have to change its entire business model of now reducing liabilities to incurring more liabilities, which would occur even if it were a bank guarantee, because members of the tribunal, a bank guarantee does not come for free. And therefore, to conclude, this tribunal must not order security for the costs of this arbitration.
Thank you. Ms. Mirani, do you have points to make on rebuttal?
Only one point, Mr. President. The defect that was committed by the claimant was not a mere technical defect. It was a defect in authority. On the 31st of May, the power of attorney that was provided was on behalf of Right Holding PLC, which is a separate legal entity and not a party to this dispute. And therefore, the first power of attorney was insufficient to initiate the present arbitration proceedings and was not a mere technical defect. Thank you.
Thank you. Mr. Vasant?
If I may respond. We do agree that this defect was in authority. However, my submission was that since a faulty application's consequences are referred to only in international arbitration practice, and our client complied with this, correcting it retrospectively, if you will note on page 21, this must be upheld as it was within the time period that the Secretariat granted to us. Thank you.
Any further questions on these issues from the tribunal at this point? Thank you. Mr. Rahija, are you ready to go?
Good morning, honorable members of the tribunal. My name is Rishabh Rahija, and I shall be arguing the merits of the case on behalf of Right Limited. Over the course of my arguments, I shall establish that respondent failed to make full payment in this contract, firstly by incorrectly applying a fixed exchange rate to the fan blades, and secondly by not paying the central bank levy. Beginning with the first claim, my argument shall consist of two parts. First, that the original contract contemplated a floating and not a fixed exchange rate, and second, that the addendum did not modify this understanding by fixing a rate for those fan blades. Members of the tribunal, the CISG is the applicable law to this contract, and therefore the CISG's interpretation clause, Article 8.3, is relevant to us. Under Article 8, subsection 3, we are to look at the negotiations between the parties culminating in the text of the contract in order to determine the parties' intentions. And both parties approached the negotiating table with one demand each, exchanging these demands. Our client.
Counsel, also according to Article 8 of CISG, an agreement has to be interpreted pursuant to understanding of a reasonable person of the same kind. How can I explain that your own employee has interpreted the whole agreement to have a fixed exchange rate?
Madam Arbitrator, Mr. Mario Lee, the accountant, was not a reasonable person in the terms of Article 8.2 of the CISG. Firstly, because he was under time pressures and time constraints, and secondly, because Mr. Mario Lee had not been acquainted with the negotiations between the parties. Under Article 8.2, the reasonable person is to be conversant with the negotiations between the parties, and as he lacked this background, he would not fulfill the threshold of reasonableness under Article 8.2. In fact, our client went on to correct this interpretation within 2 hours of the invoice being sent, and therefore it would not be in observance of good faith to interpret Article 8.2 in order to mean that a mistake can be held against our client. If I could resume my submissions.
Yes, please.
Now, both parties approached the negotiating table with one demand each. Our client's demand was that of an assurance of profitability, as costs would be uncertain and a fixed price could be below these costs. Meanwhile, respondent wanted this fixed price so that they could use our product in another contract with their own buyer. Therefore, both parties wrote these demands into the contract on page 10 of the record. You would note under the first line of section 4 that the term cost plus basis used for the calculation of the price was to account for our client's interest here, as it would take into account the costs and the plus element or the profit element, thereby assuring our client profitability. In fact, if you would look at the formula under section 4, the entire formula has been denominated in the dollar except for one element, and that element is costs. Costs are not denominated in US dollars, which means that costs are to be recovered and computed in actuality as they are incurred, after taking into account the exchange rate when these costs were incurred. Now, respondent's demand finds its place in the sentence below the formula, where a fixed price ceiling is present, which means that respondent would necessarily never have to pay over this fixed price ceiling. And I shall demonstrate that a fixed exchange rate would compromise our client's demand, while a floating rate would not compromise respondent's demand. Now, if a fixed exchange rate were to apply,
I have a question. Didn't the negotiation history of the party illustrate their intention to establish fixed exchange rate inside the contract?
if you could repeat your question, Mr. Arbitrator.
Didn't the negotiation history of the party to establish fixed exchange rate inside the contract?
Mr. Arbitrator, there was no indication in the negotiation history that a fixed exchange rate would apply, because they used the term cost plus, and only if a floating rate would apply would the cost plus basis be upheld. I say this because even if the rate were to fluctuate slightly over 5 years from $1 equals 2.02 dinars to 2.00 dinars, even this would have massive implications to our client, as our client's costs would increase by 1%, which would not be accounted for in the price on a fixed exchange rate. Considering that the profit margin here in this contract is as low as 1%, even in the best case scenario, this would compromise the cost plus basis and the profitability, which shows us that only a floating exchange rate is consistent with the cost plus basis and the demands of the parties. Whereas if we look at respondents' demand, we have provided them with a fixed price ceiling. And if I could explain this through an analogy to this tribunal, if we could imagine a tennis ball in a room, the tennis ball representing the floating exchange rate, irrespective of how much the tennis ball were to bounce, it would never go above that ceiling, which means respondent was facing neither risk nor uncertainty, as this ceiling was known to them for their other contract with Earhart SP, and they could fix the price accordingly. If I could now, I sense a concern.
Counsel, but if it was such an important provision for you, why Mrs. Bainhorn reviewed the terms of the addendum and considered them to be acceptable?
Madam Arbitrator, that brings me to my second argument on the addendum. And before I get into my answer, we should note what Miss Amelia Bainhorn was referring to when she agreed and what the implications of that would be. Now, what was being negotiated in the addendum was clamps, and the value of the clamps was about 0.8% of the value of the fan blades. Therefore, any currency risk on the clamps would be at most negligible to our client and uncomparable to the currency risk on the $20 million worth of fan blades. And now, if we look at respondents' proposal for the addendum on page 28, the 2 points of focus in this email are the context and the text. As I stated, respondent has contextualized the addendum in terms of the agreement for the clamps. The subject states clamps. This comes after a phone conversation where only clamps were discussed. And in fact, the first paragraph of this email emphasizes the clamps, talking about a purchase of the clamps and a contract for the clamps being negotiated. Therefore, a reasonable person reading such a clause or such an addendum would understand that it pertains only to those clamps and not to any other undiscussed item such as the fan blades. And we should look at this in understanding what Miss Amelia Bainhorn was referring to when she stated, "I also agree to the fixed exchange rate" in regard to the clamps.
Counsel, if I might, before you move off the addendum language itself, are you arguing that the addendum is clear, or do you see ambiguity here that you wish us to interpret?
Mr. Arbitrator, to a reasonable person, it would be clear from the context and from the text that the addendum was referring only to the clamps. However, if we were to assume ambiguity, we would have to interpret, or rather use that ambiguity against the drafter under the contra proferentum principle, under the CISG and the unidraw principles, and find that respondent's interpretation should not be preferred here.
Counsel, what confuses me is the order of language in the addendum. It appears that it is a 3-paragraph addendum. The first paragraph expressly deals with clamps, including dealing with cost. There is then a second paragraph that leaves clamps and talks about the overall agreement, reconfirms other elements of the agreement. And then there is a third paragraph that deals with the agreement's exchange rate. It would appear, wouldn't it, that the use of the word agreement coming 2 paragraphs after the discussion of clamps creates an inference that the exchange rate is for the entire agreement.
Mr. Arbitrator, there are 2 pertinent points for us to note here. Firstly, there is another way to view the structure of this particular addendum and its 3 paragraphs. Firstly, the first paragraph laying out the general sale terms. the second paragraph laying out the other general rule for the addendum and the clamps, and the third paragraph being the exception to that rule for the clamps. And if we were to interpret it in that manner, we would understand that the agreement being referred to is the exception to the same clamps. And with respect to the second part, on the usage of the word agreement, the parties have consistently used a capital A when referring to the fan blades throughout the contract on page 10. And under the CISG, this could become a binding pattern upon the parties or a defined term, and any deviation from this defined term, such as a lowercase a, would naturally be referring to another instrument. And thus, I conclude that the addendum did not modify the floating exchange rate that would apply to the fan blades, entitling our client to the difference amount. And if I could now move on to the second claim, members of the tribunal, before I move on to my argument, there is one very important consideration for us to note. This particular fee was charged under the ML 2010C regulation, and this regulation is extremely relevant to the buyer, as had compliance not taken place with this regulation, payment would not have even happened into our client's account. And in fact, full compliance has not been made by respondent here, and therefore this is clearly a regulation that must be taken into account as directly relevant to the buyer's obligations to make payment. I sense a concern, Madam Arbitrator.
Yes, I have a question. Wasn't claimant's obligation to inform respondents about the levy under Article 35(2) of the CISG?
Madam Arbitrator, the relevant provision of the CISG for us here is Article 54 and not Article 35, as Article 54 deals with the buyer's obligations to pay, which is what we are concerned with, while Article 35 deals with the seller's obligation to deliver conforming goods. And there is a differential threshold between these two provisions, as Article 54 requires the buyer to comply and inquire about any laws and regulations, be it in the buyer's country or in the seller's country. And the reason for this differential threshold is threefold. Firstly, the buyer has fewer obligations than the seller under the CISG, and therefore a higher threshold for performance is expected from him. Secondly, the buyer has fewer regulations to comply with, while the seller would have to look at safety regulations, packaging requirements, health standards, and so on. And finally, the buyer can find out about all regulations at the one-stop shop to him, which is the central bank, whereas the seller will have to inquire with the specific departments of each relevant industry. Therefore, here, the duty in good faith was upon the buyer to inquire and not upon the seller to inform.
But counsel, can't the lack of information be compared with a violation of the duty to cooperate with the buyer and therefore liability under the Article 80 of the CISG?
Madam Arbitrator, if I could request 30 additional seconds to answer your question. Now, it has been noted that the obligation under Article 54 is to be interfered with by Article 80 only in the case of impossibility. And here, it was not impossible for the buyer to know about this regulation, as its own national media had made some reports about these regulations. And secondly, Article 80 is an all or nothing threshold, which means our client would have to make it completely impossible for the buyer here to find out about this regulation. But they had the means at their disposal to do this even without our client's information. And this is, as per the opinion of Professor Huber, the position under Article 80. And therefore, to conclude, I request this tribunal to uphold the position under the CISG and find that the buyer should have made full payment in this contract, including this particular fee. That concludes my submissions. Thank you.
Thank you. Ms. Chilera, ready to proceed? Since it appears to be standing directly in your way, Would you mind responding to Mr. Raheja's point about the CISG, particularly Article 54?
Would you like me to begin my submission with Article 54?
Yes, please.
Okay, thank you. A very good morning, members of the tribunal. As introduced previously, I'm Mahima Chalera, and I will be responding to the substantive issues raised in the present proceedings. Members of the tribunal, both parties in the present dispute are specialized manufacturers of the aircraft industry, and cooperation between such parties forms the bedrock of this industry. And in this regard, I will establish that while as a buyer, my client cooperated in the successful manufacturing of the fan blades, the same cooperation has not been extended by the claimant, who is the seller in the sales transaction. To proceed with the question posed by Mr. President in regard to Article 54 of the CISG, members of the tribunal, now we do agree that Article 54 of the CISG requires a buyer to comply with any law and regulation to enable payment to be made. However, the CISG requires the tribunal to read every provision in light of the general principles of the CISG which underline this convention, particularly the general principle of good faith and reasonableness. Now, while my opposing counsel has requested this tribunal to not rely on Article 35 of the CISG on account of the difference in the obligation that has been undertaken, but members of the tribunal, the CISG today is internationally accepted as a sales convention for balancing obligations between a buyer and seller. And this balance is only achieved by providing similar treatment to parties when they are placed in similar circumstances. Now, we do understand that under Article 35, a seller has an obligation to produce conforming goods, while under Article 54, a buyer has an obligation to make the payment. But both these obligations are primary obligations that a party undertakes in a sales contract. And what we seek to impose from Article 35 is the corresponding duty being imposed on the parties. And this corresponding duty and its nature is very similar. Members of the tribunal, the conundrum that is arising in the instant case is on account of the fact that this is an international sales contract. Both parties belong to different jurisdictions, and regulations emanating from such different jurisdictions can potentially affect performance obligations of foreign parties. Now, the view that CISG requires tribunals to undertake in such situations when regulations emanating from one party's jurisdiction affects the performance of the other party is to see as to which party is most reasonable, economically efficient, and easily accessible to this information. And therefore, it has been held in various cases where such regulations have affected the performance of foreign parties that a party in whose jurisdiction such regulations emanate was indeed under a duty to inform the other party. Now, members of the tribunal, if I may bring you to the facts of this instant case, which requires this duty to be imposed on the claimant, particularly in light of the fact that this regulation was not in accordance with international practice of money laundering. And second, this regulation was not directly a payment-related regulation, but rather a policy-based decision that the claimant's country took and was criticized by business associations in the claimant's country. If I may direct your attention, therefore, to page 54 of the record. I apologize, page 55 of the record. Under paragraph 7, the 6th line reads that although this regulation was based on UN model legislation, paragraph 7 on page 55. The 6th line reads that this regulation was based on a UN model legislation, but unlike what other countries in the world did, the approach that claimant's country had adopted and was highly criticized for was the charge that it was levying pursuant to this regulation. Members of the tribunal, compared to 190 countries of the world, only 6 other countries had a similar approach. And what was reported in my client's country that claimant's country had merely taken actions against money laundering.
Counsel, but doesn't the DSA attribute to respondent the obligation to pay such fee, according to Section 4?
Madam President, if we look at the DSA, what has been obligated to the buyer under it is the responsibility of bank charges. Now, this charge, which has been charged pursuant to a government regulation set up by a financial intelligence unit, and the proceeds go to the government or the Ministry of Finance, was not a charge that can be termed as a bank charge within the DSA. And further, members of the tribunal, the obligation of the buyer was to pay the charges for transferring the payment, and this charge was for investigating the transfer for money laundering. And therefore, it is our submission that keeping the facts and circumstances of this case and the international character of the CISG in mind, claimant was under a duty to inform my client. And this is especially relevant because even claimant's negotiator, who belonged to that same country, was not aware of this charge while negotiating this contract with our client. But they expect a foreign party from a foreign jurisdiction with absolutely no reason to have knowledge of this regulation to be aware of such a specific levy. And therefore, members of the tribunal, if I may revert first to address my opposing counsel's submission in regard to the exchange rate. I would request the tribunal to move back to the tennis court laid out by my opposing counsel on page 10 of the record. However, before we proceed to describe this tennis court, members of the tribunal, on page 10, it must be noted that this tennis court exists in the vacuum of US dollars. And I would like to humbly disagree with my opposing counsel, who has stated that even costs in this tennis court were mentioned in EQD or a local currency. If you will please look at the first line under Section 4, it clearly states that production costs per blade when less than 9,500 US dollars. There is absolutely no mention of Equatorial dinars on this price structure which was adopted by the parties. And therefore, members of the tribunal, if at all the ball moves in this court, it is because of the increase or decrease in the costs on account of manufacturing costs, and has absolutely no relation or no impact by the fluctuations of the exchange rate, which are external situations